Hello and welcome everyone. Thank you very much for joining us for today's webinar. My name is Dan Sampaio and I'm hosting on behalf of Mondaq. I'm delighted to be joined by Mr. Gönenç Gürkaynak, whose work I'm sure many of you are very familiar with. Mr. Gönenç Gürkaynak is a founding partner of Ilig Gürkaynak Attorneys at Law, a preeminent and leading law firm in Istanbul, Turkey. Today, Gönenç will lead you through contemporary developments in Turkish competition law and the effects of the recently revised law. Now, before we get started, I'd like to go over a few items so you know how to participate in today's event. You're listening in using your computer speaker system by default. If you would prefer to join over the phone, just select telephone in the audio pane and a dial-in information will be displayed. Now, if you want to participate by offering a question, please use the panel on the right-hand side of your screen. Gönenç will try to get through as many of these as possible during the presentation, but if we do have questions we don't get to, we will answer them after the event. Now, it is my great pleasure to hand you over to Gönenç. Thank you very much.
Thank you, Dan. We will be discussing contemporary developments in Turkish competition law today. And what is the most impressive contemporary development has been that finally, after years of churning, going to the Grand National Assembly, not passing, in a new Grand National Assembly being tested, tried again, so the parliament trying to pass the law, the revised legislation is now enacted and passed, so it's a part of our legal system. And 3 months has passed on a period of 3 months has passed on the passing of this new law that brings in quite dramatic changes to Turkish legislation. People who are familiar with the EU competition law might find that a lot of these changes are to harmonize the Turkish regime with the EU regime, which is no surprise because the inception point of the Turkish competition law was an idea really of harmonizing Turkish legislation with that of the EU. But then people who have followed the developments in Turkey for about 25 years now in the competition law field must have observed that while the law and the secondary legislation looks quite a lot like that in the EU, the decisions of the Turkish Competition Authority have from time to time had a backbone of their own. They had policy preferences of their own. And ultimately, the Turkish competition law is not merely mimicking what is available in the EU, and it has habits and traditions of its own. The Turkish Competition Authority has been active since November 1997, so we're looking at 23, 24 years. The law has been in place since 1994, so we're looking at a good 26 years there, which means that in the global scale, where now we're looking at very many countries having a competition law regime, the Turkish competition law regime is one of the more mature competition law regimes. And it's not only by way of counting of years that have passed, but also in terms of the administrative capacity that is devoted into the Turkish Competition Authority, the sophistication of enforcement, the kinds of cases that they take on, the sophistication of the competition law bar in the country, the use of comparative tools, their interaction with their counterparts elsewhere in the world, and the types of allegations that are pursued. These are all indicating to the fact that the Turkish competition law is getting more and more sophisticated. That doesn't mean to say that everything that the competition authority does is correct. You can't say that about any competition authority or any agency or any decision-making body, really. But it should be said that they have their hearts in the right place, and the Turkish Competition Authority is trying to penetrate with a technical understanding of competition law. And the Turkish Competition Authority has been coming up with cutting edge type of enforcement in different types of cases. Different chambers are taking on different types of areas of responsibility according to sectors and relevant product markets. And that allows the competition authority to develop a sophistication in terms of their understanding of the dynamics of a relevant market when enforcing Turkish competition laws. Against that background, now, finally, since June 2020, we have new tools and mechanisms available to the enforcer and also to the defense attorneys, such as myself, where we can have a bit more room to maneuver as defense attorneys. And in contrast, the Turkish Competition Authority would have a bit more room to maneuver when choosing their battles. They will be able to focus on certain cases more than others, and they will have less of prescribed solutions that have to fit every fact circumstance, and more of their own assessment of a matter and its competitive effects. So let's look into what has happened and what that means in the midterm for Turkish competition enforcement. If you could, Catherine, go for the next slide. Let's see. Now, as I said, it was June 17, 2020, and the main reason behind the amendment law was that there could be a new push for a quote-unquote modernization of the Turkish competition law regime. The European Commission's progress report about Turkey typically has good things to say when it comes to competition law. I can't say that it typically has good things to say in many of its chapters, like when it comes to freedom of speech, when it comes to democratization, when it comes to very many fundamental rights related issues. The European Commission's progress report is always one that is an eye-opener, a matter that has to be focused on to benchmark the progress of the country. Yeah, but when it comes to competition law and competitiveness in general, the report typically recognizes, rightly so, that there is a sophisticated competition authority, there's a sophisticated body of precedents, there is a tradition. This has been going on for decades now, and the Turkish competition law in its own right is a force to be reckoned with, especially at this part of the world, so it's a regional leading authority as well. That said, because of that sophistication, your responsibilities are higher too, and the report was arguing that Turkey needs to harmonize the legislation with the acquis by introducing the minimis commitments and settlement procedures and amendments in merger control. So this is the law that has passed is closely mirroring what is in the progress report. This doesn't mean to say that suddenly a progress report in 2019 came in and the legislation has changed. This attempt was there for a very, very long time. As I said, it has gone to the Turkish Parliament, which is the Grand National Assembly, but it has not had much of a traction for a few terms. There was always a crisis mode on one front or another, so you would have to wait for these kinds of day-to-day legal landscaping to take priority, which never happened. But ultimately, mid-June 2020, we have managed to get these kinds of legislative changes in place, which will obviously give a better toolbox to the competition authorities, case handlers, the board, which is the decision-making body of the Turkish Competition Authority, and also the defense attorneys in the competition law side or merger control filing entities, as we will describe. Next slide, please. So the amendment law in very general terms. So in this presentation, I'll be using a larger periphery to explain, and then a narrower periphery, and we will go into the nucleus of the discussion. What does the amendment law do? This is the larger periphery exercise. It clarifies certain legal uncertainties in the practice, and it puts into context what truly is the authority of the Turkish Competition Authority in terms of jurisdiction, in terms of powers to act. The reason why this was necessary is because over the years, the Turkish Competition Authority has assumed certain powers using certain concepts in the existing legislation, and also looking at what is being done elsewhere in the progressive and more sophisticated competition law jurisdictions. But it didn't always mean to say that the Turkish Competition Authority squarely had a legal basis for that interpretation. It was the thing that is done in the world. It was also a thing that was done by very many sophisticated antitrust enforcement agencies like the FTC or the Bundeskartellamt or the CMA or the Commission or JFTC, what have you. But ultimately, you needed legal background for it, and this legislative change is putting aside some of those debates as to whether, yes, we understand that this is being done elsewhere in the world, but where is the legal underpinning of this in Turkish law? It also introduces new mechanisms to be able to focus on certain cases. Because it allows for the smaller fish really to be thrown back into the pond, and it brings a new substantive test for merger control matters, meaning what is a significant case, what is a risky a merger control matter, what is leading to concerns, is going to be defined more on account of actual effects or actual potential effects, and less on the issue of prescribed definitions such as having a dominant position or strengthening an existing dominant position. You could argue, I argue, that even with that test, you had enough room to maneuver, because ultimately only having a dominant position or only having a situation where you strengthen an existing dominant position was not enough for there to be a rejection decision anyway, and the rest of the test was already doing the trick in my view. But I'm not saying that it was unnecessary to switch to the SIEC test, as I will explain. There are also new procedural tools, especially settlement and commitment, which allows the competition authority to choose its battles, the investigated entities to be more candid with the Turkish Competition Authority, and public resources to be allocated at places that they're more needed, basically. Next slide, please. So on the de minimis matter, basically, it is very much like what is available in the EU. For those of you who may not know what is available in the EU, the de minimis principle allows for the smaller fish, as I said, to be thrown back into the pond. So, basically, you could say that the Turkish Competition Authority won't have to run after some cases that can be dealt with only with a letter that is sent to the parties or a threat of enforcement, and they won't have to deal with a full investigation that is consuming about 18 months of their time and 3-4 personnel and hundreds of time of administrative nature, when a matter is too small to have an appreciable effect on a meaningful part of the markets in Turkey. For that, there will have to be an objective criteria, because one of the worries, especially in a country like Turkey, where there's always a worry that there could be political influences and all that, and I should congratulate the Turkish Competition Authority that we are not observing that kind of a trend so far. but there's always that kind of a worry for understandable reasons, as in Turkey there is more and more talk about what the judicial authority should do, shouldn't do in the political sphere, when even your judicial branch is hit with that kind of rhetoric and life experiences, then people obviously start suspecting whether a part of the agency, which is the Turkish Competition Authority, independent as it may be, could be hit by the same kind of influence. So a de minimis principle type handling might become a tool of certain entities, certain persons being liberated, certain others finding themselves under the heat of enforcement. And to avoid that, you have to have objective criteria, which is what the legislation is doing. The legislation says there should be a secondary legislation, and through market share and turnover thresholds, you can determine the de minimis scope, which means how small should the fish be to be thrown back into the pond. If it's a hardcore violation, such as price fixing or territory or customer sharing or restrictions of supply, so things that go into the very heart of welfare in a society, then there will be no de minimis, which is also in line with what is happening elsewhere in the world. Next slide, please. I won't take too much time on this particular slide, but it is important to note that there is already some use of the de minimis principle. Even without the de minimis principle, the board was attempting to use the de minimis principle way back. I think it must be about 1999 in one of my cases for ABB. There was a use of what I would call a de minimis principle without calling it that. And then there have been an intermittent use of the de minimis principle on and off. And the Izmir container transporters decision is also a good example. The infringement affects only a small market. It's not an infringement that is of hardcore nature, so it's a candidate for de minimis. Again, if it's hardcore, even an infringement that has very little potential for effect in terms of its geographical scope or in terms of its relevant market being very niche, it won't be benefiting from the de minimis principle, and the Turkish Competition Authority will pursue this kind of a case. Next slide, please. So overall, what will the de minimis notice do? It will, I'm using future tense because we don't have the secondary legislation just yet. As I said, even the law has passed quite recently. So once the secondary legislation passes, the de minimis is expected to come up with a market share prong. It could be 10%, 15%, somewhere around there. We know this because that's what's happening in the EU. With our percentages, we've typically been different in other secondary legislation from the EU as well. So we might have that kind of a situation here too, but it's not going to be too far out. And in general terms, there will be some form of reference to the overall commercial gravitas, commercial magnitude of the entities involved, so that it is secured that this fish is small enough to be thrown back into the pond. Next slide, please. There's a significant change in the legislation, that is the switch to the SIEC test, which is a test for significant impediment of effective competition. Now, this is going to allow the Turkish Competition Authority to do two things more comfortably. One, the Turkish Competition Authority was already coming up with certain articulations of competition law concerns in cases where they can't really demonstrate the existence of a dominant position, they would try to sometimes dress it up as collective dominance. They would sometimes, put vocabulary in for structural links leading to network effects and all that, which are legitimate theories of harm in competition law elsewhere in the world as well. But when you don't have a dominant player at hand, or a situation of strengthening of a dominant position, which already readily requires the existence of a dominant player, then you might find yourself in a situation where a technical black letter law kind of defense prevailing over your concerns, which are actually quite valid. So now, with the significant impediment of effective competition, those kinds of worries can be articulated a little bit more broadly. It's a bit more relaxed now. Also, vice versa is true. So in instances where a strengthening of a dominant position is what you're looking at, the Turkish Competition Authority was always raising a flag. At least you would risk going into a phase 2 because one prong of the test is already met, and that doesn't happen very frequently in Turkey anyway. And to see whether the remainder of the test, which is lessening effective competition in the whole or part of the country, and the second prong of the test is met or not, you would have to basically go closer to a phase 2 type analysis. Sometimes it would be dressed up in a phase 1, but the durations would still be many months of a phase 1 review. So you would know that, under the pretext of a phase 1 review, you're being subjected to a phase 2 review. And if the Turkish Competition Authority were to take a decision and say, you know what, I don't see a problem here, I'm not going to launch a phase 2 too early, and without filling up the file with a lot of affidavits from the field and doing groundwork and all that, then the complainant, or if there's no complainant, the plaintiff of an appeal could bring it to court and say, I'm not saying that they have to reject it, but they should have launched a phase 2. I mean, after all, the first prong of the test is met, right? And the courts would be confused with that. With this new test, now it is a matter of whether there is a significant impediment of effective competition, which in turn means that the Turkish Competition Authority may demonstrate in some instances where there is actually a market power that is not demonstrated for reasons explained in the file, and for tests that they have done, they haven't seen that there is a significant impediment of effective competition, and that's the test. So it might be easier for them to close borderline cases in phase 1. It allows for obviously a more reliable assessment for the unilateral effects as well as the cooperative effects, as I explained. And as I explained, over-enforcement would be curbed if it is used wisely and correctly. If it were to be used only to bolster the worries and theories of harm, but never to actually look into whether there is significant impediment of effective competition in a case where there's some tangible market power, then obviously it's a lost opportunity. So for it to be a balanced kind of an enforcement impact, it will mean that the dominant undertakings contemplating transactions with de minimis impact might also benefit from this new approach. Next slide, please. Another important and interesting prong of the new legislation is that behavioral and structural remedies for anti-competitive conduct is introduced. For there to be structural remedies imposed by the authority, there has to be behavioral remedies first applied and failed. This does not mean, and people confuse this quite a lot in Turkey right now, even sophisticated practitioners sometimes. This does not mean that you have to come up with a behavioral commitment when you're trying to solve a matter, and that you cannot come up with a structural commitment or remedy proposal as a defense attorney from the get-go. That you can do. But for the Turkish Competition Authority to ex officio come to you and say, I'm imposing behavioral remedies, or you should think about coming to me with behavioral remedies, that is the only route. Before doing that, before imposing it and seeing that it failed, the authority cannot in and of itself go for a structural remedy. This is also security in the sense that the Turkish Competition Authority will not be buried under criticisms that they are reshaping markets with an ulterior motive. Remember all the discussions about the Turkish Competition Authority independence, whether political influence could use competition law as a gadget of wealth transfer to people sympathetical to the current government and all that. You can actually, if you were to go into the history of evolution of this legislation, you can see that this is taken into account in the legislative process as well, because it wasn't this clearly written in the previous drafts of this legislation that behavioral remedies should be first applied and failed. There was a hint that the first pit stop is behavioral remedies, but you could still argue, how much of a bar or a precondition or a condition precedent of the move into the structural remedies zone is this. And now it's unequivocally clear that first behavioral remedies should be applied and failed for there to be structural remedies discussion if it is ignited by the Turkish Competition Authority. To the extent behavioral or structural remedies are being imposed by the authority, they have to be proportionate and necessary to end the infringement effectively. So there's a proportionality test, which is a requirement not only of the harmonization goals with the EU legislation, but also of the Turkish constitution, especially to the extent you're dealing with fundamental rights or property rights of individuals, I should say, and property rights of individuals. This is the same for the decisions of the European Court of Human Rights as well. Ultimately, the European Court of Human Rights is seeing this proportionality, this particular proportionality at this point, as the security measure that these remedies are in line with fundamental rights of entities and individuals alike. So basically, these kinds of remedies will be exceptional, and if they are proved to be ineffective, then structural remedies can be introduced. This is different than what you see in the EU, because the EC regulation number 1/2003, so way back in the day when we called it competition law, attorneys as experienced as I am or as old as I am will remember that we used to call it the modernization. When the modernization was coming in, proving to be ineffective of behavioral remedies has not been a prompt. So the Turkish legislation is taking it farther than that, and the reasons I have explained. Next slide, please. Here, I'm not going to take too much of your time. Ultimately, the board will grant some time. If the behavioral remedies have failed, the board will grant a minimum time period of 6 months for compliance with structural remedies, starting from the final decision, meaning you will get the decision. There will be few months for the writing of the full reasoned decision, and you will be already working on compliance, and then the full reasoned decision will come and show the internals of what form this structural ramification should take, and then on top of that you will have 6 months. I'm not claiming that this is a long time, because people dealing with corporate law will know that especially for certain structures, 6 months plus the full reasoned decision being written let's say 9 months is going to be a very, very tight ship to run. The first behavioral and then structural remedy bit might lead to certain communications between the defense attorneys and the Turkish Competition Authority's case handlers as well. For example, the case handlers might hint that while these behavioral remedies are being imposed, this is because the legislation is forcing their hand to do that, but they don't think it's going to cut it. They think structural remedies will be necessary. So the entity might, while complying with the behavioral remedies, might also start looking into structural remedy formats, may want to propose structural remedies and all that. Unfortunately, the legislation isn't clear as to whether it is possible to swap from a behavioral remedy imposed by the Turkish Competition Authority to a structural commitment proposed by the defense attorneys, and that might become necessary as we proceed. Next slide, please. So there's a commitment procedure and a settlement procedure. In the commitment procedure, if there is an infringement, you can go to the Turkish Competition Authority without conceding the existence of an infringement, indicate that it seems like if I were to commit this and that and the other to you as things that I will do or refrain from doing in the marketplace going into the future, then all your problems are going to go away. And this is a sophisticated type of infringement, so you probably didn't expect me to see it immediately that this is an infringement. Therefore, your zeal to give an administrative monetary fine to me must be low. I wouldn't expect you to be very enthusiastic about giving an administrative monetary fine to me. Your reason for being passionate about this enforcement must be to shape the market and my market behavior into the future. I can give you that. That's a commitment language. In that case, if the authority were to say, okay, give me a commitment a proposal and we'll discuss that, and I won't expect you to concede, to accept that there is a violation, but I will expect you to adhere with what commitments you have given to me and to keep your promise, basically. That's a commitment type of a negotiation. On the other hand, if there is a violation being alleged, and actually there aren't commitments into the market behavior, and rather, it's very clear that this is an infringement and there was something that you should not have done, and it was crystal clear, and it's done by you anyway. And now you come and you say, yeah, okay, I did this. I apologize. I concede the existence of the particular violation, and I would like a reduction in administrative monetary fines for settling with you, for saving public resources. Then that's a settlement procedure. Of course, this conceding it and saying, sorry, bit might occur to new students of competition law, if there are any attending, as weird. Why is this necessary? But there are a few reasons as to why this would be necessary. One, the way the settlement legislation is written in Turkey does not allow for the settlement proposer whose proposition has been adopted by the authority and who has secured a settlement and therefore a reduction in fine to then go to the administrative courts and appeal the final decision that is the poster child of a settlement procedure. That you can't do. So you have to already in official form say, I have infringed, and you have to make it clear that this was, to your understanding, to your benefit, and that's why you did the settlement. With commitment, there is no such language in the law in Turkey. So with commitment, it seems you can then take matters to a court. But obviously, I can imagine the legal services department of the Turkish Competition Authority trying to draw a parallelism between settlement and commitment. It didn't need to be written in there. It's against the spirit of commitment and all that. But it's not going to be an easy sale. Also because in settlement in the EU and elsewhere, you're not categorically barred from going to court either in some sophisticated enforcement regimes. Not all of them, but in quite many of them. So to backtrack our thoughts, in the settlement procedure, you will concede, and one other thing will happen, which is that basically you will have realized that the Turkish Competition Authority is done with you and you get whatever administrative monetary fine you get. But after that, private litigants can come up with a private enforcement lawsuit, a follow-on lawsuit for their recovery of their damages. What am I meaning to say? For newer students of competition law, if there are any, what this means is that the Turkish Competition Authority will close the file, but courts may open them depending on plaintiffs bringing cases in the form of civil action. And Turkey, it will be interesting to colleagues attending from abroad, from outside of Turkey. Turkey is a jurisdiction where there is a treble damages clause in the legislation. So you not only compensate your damages, but you treble them before compensating them. So you open yourself up for that kind of enforcement, which obviously is going to mean that more and more entities that are thinking of a settlement might grow a cold feet because of the potential that you have conceded the existence of a violation. Well, in a torts action, which is what it is ultimately, the civil action takes the form of a torts action. When you go to the court, what you need to prove is the illegal act. After proving the illegal act, you also prove the damages, the nexus between the illegal act and the damages, and who perpetrated the illegal act. Now, the illegal act prong will be announced by the entity for the settlement, except for the damages, really. Nexus and everything will be announced. That's the part where the entity will have conceded. And then the exercise is going to be reduced to an expert witness being assigned in a jurisdiction like Turkey for the calculation of damages and trebling it, basically. So it exposes entities to quite a bit of risks, and that might mean that the settlement mechanism may not sell as highly as it sells in some other jurisdictions. Also, we're seeing that the leniency regime is not working as rapidly and effectively in Turkey as well. There aren't that many cases in Turkey, and that parallelism also gives you an idea that perhaps international entities might be too keen to avoid conceding that kind of a position in Turkey to protect their reputation, or they might think that this might have a domino effect in other jurisdictions. So they should not start this kind of a ball game. They would rather fight it out for as long as they can, and they would not only gain time, but also they would try to make sure that they're not conceding the existence of something that they don't believe. What I mean to say there is that sometimes when you go in for a settlement, the competition authority might require you to over-undertake certain things that you have done, because if you have only shown the tip of the iceberg and in the settlement the portion that you have conceded wasn't candidly the entirety of the illegality, this could be a problem for the health of the settlement going into the future. And the more sophisticated this exercise gets, the less interesting it might be for the entities looking into it. Next slide. This I have explained, so I'm not going to look into this slide. Next slide, please. Right, so commitments, they will not be accepted for naked or hardcore infringements. What are these? Infringements that go into the very heart of public welfare, be it consumer welfare or social welfare, price fixing, territory sharing, customer sharing, restriction of supply, those kinds of hardcore restrictions. They won't be a fair gameplay, game field for commitments. For commitment procedures, we will have to wait because there's going to be a secondary legislation. How will the commitments be published? Because third parties that are interested in these commitments will have to know about the existence of these commitments. How will they be negotiated? What types of commitments are more likely to work than others in certain given fact circumstances and all that. As I explained, in the commitment side of things, it seems that you will be able to take the commitment decisions to administrative courts because there's no explicit language that bars you from doing that, whereas for settlement, there is explicit language doing that. Our legislation says naked and hardcore violations are exempted, whereas in the EU law, it just talks about cartels. So when you say naked and hardcore violations, it feels that certain sophisticated forms of information exchange, even if it can't be termed as a cartel, for example, could be seen as a naked and hardcore violation. Query whether it can be dressed up as a cartel in the EU as well, but there's more room to maneuver for the Turkish Competition Board, basically. Next slide, please. So if the investigation ends with a settlement, the board can reduce the administrative monetary fine by up to 25%. This is different from what is available in the EU, which is a 10% threshold. But then it makes sense because what you're looking at as a risk factor in Turkey is the Turkish turnover, including exports from Turkey. So net sales in Turkey and exports from Turkey, outbound from Turkey. This would constitute the entire universe of what is being fined, and then you would be looking at 25% of that. Whereas in the EU, you would be looking at global turnover. So it's a different ballgame, and the percentage references being different makes sense. It has to be worthwhile for the parties. If you were to say 10% of Turkish, 10% of the administrative monetary fine in Turkey, it basically comes to less than 1% in any calculation of the entire turnover. So to sweeten it up, basically, it is stipulated as 25%. Next slide, please. Now, as I said, third parties can demand compensation after the acknowledgement of the violation through settlement, in settlement. And the treble damaging is possible here. So you can't say that you had agreed with the competition authority from an administrative perspective to get rid of the administrative monetary fine, but if you're going to be subjected to civil action, then it's a different position you're taking. Your admitting of the violation will also be reflected into the civil action side of things, which might be an issue to bear in mind, which will be an issue to bear in mind. Next slide, please. I've explained these so we can, while giving you an account of the situation, so we can proceed. The differences with the EU matter. There is quite a bit of change on the on-site investigation process. On-site investigation meaning down raid. So unannounced visits of the Turkish Competition Authority raiding private entities, looking into their digital and physical environment, taking copies of their documents, and also perhaps soft copies of software, and more and more these days, also even looking into WhatsApp messaging and all that. Now, the authority, it says, may inspect, the new legislation that is, may inspect and make copies of all the information and documents in companies' physical records, as well as those in electronic clouds and IT systems. This is new and important. Before, it was being discussed that the Turkish Competition Authority doesn't have the actual legal authority to do some of the stuff that it has been doing. Such as going into the server, taking certain correspondences from the server, deleted items from the server, and all that. The authority was still doing this, but the legislation was just saying it can take copies of documents of the businesses, the enterprises, and do they mean to say that you can go onto the cloud? Yes, I understand you can come to the desktop terminal, but can you really go to the server? What if what you are inspecting in has a gateway to a broader medium implicating other entities or other geographies beyond Turkey? Now, the Turkish authority is still building mechanisms in there to secure proper access. So that they don't go overbroad, because ultimately they're bound with an authorization certificate that is given to them by the Turkish Competition Authority. But whether they have the means to take copies or look into take copies of or look into the soft copies of documentation, go into the electronic systems, go up into the cloud and all, there's no doubt about that. This is a clarification on the powers of the authority, really. As I have indicated, the authority was taking all kinds of information and documents from the company's electronic spaces and information systems anyway, but now there's going to be less of a debate on the legal grounds for it. Next slide, please. So the self-assessment regime and procedure is underlined. There will be less of applying for an individual exemption for violations of Article 4, which is akin to Article 101, and there will be more of self-assessment as to whether this would get an individual exemption if the Turkish Competition Authority were to look into it sua sponte, ex officio. The option to apply to the board for an individual exemption is still available. We did have a self-assessment procedure before as well, so it doesn't mean that we were in a world of pre-modernization, as I said, so pre-2003 world of the EU. We were already in a self-assessment zone, but now it's clearer and it applies to a larger median of competition law acts, such as the concert practices, decisions of associations of undertakings, and whatnot. Next slide, please. There is a crucial procedural but crucial change in the legislation in terms of time extension for the authority's additional opinion in investigations. Prior to the amendment law, the authority had 6 months to finalize their investigation report, but this period was extended with an additional 6 months by the board. And then the additional opinion had to be served in 15 days after the second written defense was brought in. So to give you a full picture of how it was happening, the downraids were happening in the pre-investigation phase. Then with the evidence collected and the theory of harm formulated, the case handler team would go to the board and either advise that there be a full investigation or advise that there be a closure of the file. The board is not bound by these advices, recommendations. And then the board highly likely would follow the recommendation of the case handlers, because at that point it's rarer for them to take an exception to the case handlers, but they may do it, and there are cases where they did it. And then a full investigation would start with an investigation notice. That investigation notice would be a relatively shorter document that does not contain all of the evidence body and all of the theories of harm, and it looks more like a fishing expedition, really. And the experienced counsel would, in turn, make sure that the experienced counsel should not come up with all its weapons glaring, coming up with all kinds of theories of harm that aren't formulated, and coming up with particular defenses. Now, in the current period where there is an investigation notice, the investigation notice would give you 30 calendar days for a first written defense. Then there would be 6 months plus 6 months for the authority to provide what is the backbone of their allegations, that is the investigation report. This is what is akin to the Form CO in the EU. And then when you get it, you would know that you are looking at all of the evidences and all of the theories of harm, and there will be no expansion of the allegations any further. You have 30 calendar days, extendable by another 30 calendar days. So in 2 months, the defense attorney would provide the defense. And in that 2 months period, you would be producing the backbone of your own defense document. So that's the seminal defense document that is put in. Despite the fact that you would be countering an encyclopedic document with an encyclopedic document in most investigations, suddenly the case handlers would be under a duty to prepare an additional opinion in 15 calendar days, which is bad for both parties. For the case handlers, there's an undue burden on them, and they can't deal with all of the defenses adequately in their additional opinion. For the defending entity, it gives you a feeling that they could not have possibly read all of my defenses and actually factored them in adequately. I worked on this for 2 months, day and night, and suddenly in 15 days, I'm getting this rather short document that is called the additional opinion. So after the additional opinion, you provide your third written defense, then there's the oral hearing. So as you can see, the built-in mechanisms of an investigation in Turkey are quite powerful in terms of defense rights. And then there would be, in 15 days from the oral hearing, there would be a decision of the Turkish Competition Authority, appealable at administrative courts. Now, the amendment law finally also includes an option to double the time period for the submission of the authority's additional opinion. And I'm pretty sure that in all investigations, the authority will use this, because 15 days is really too short. So they now have up to 30 calendar days to submit their additional opinion in full-fledged investigations, which is also okay in terms of the equal powers of defense and allegation, as the defense will have 30 calendar days as well. Now, I'm seeing that there is a question as to whether these particular changes, all of these, are already available in the existing investigation. So what happens if in June 2020 there was already an investigation underway, and then this legislation has passed? Does it mean that they can approach you for commitments? Does it mean if you have a merger control filing, they're going to use a SIEC test now? And the answers are all yes. Basically, that's the law of the land now, and these approaches will have to be used starting from that day. And we're seeing that they are being used in certain investigations. The tone has changed, the approaches have changed, and these tools are being used at the moment by our law firm and by the competition authority as well. If the audience has any questions, by the way, please feel free to write them down and send them, and they will be forwarded to me immediately, and we will deal with it as we go along. There was already one question, and now I have answered that question. Next slide, please. Right, so basically, as I have explained, 6 months plus 6 months and then only 15 days. Now it is the authority having 30 days instead of the 15 days time period. This is going to relieve the authority from the burdens of producing something meaningful in only 15 calendar days. And it's also going to provide some relief to the Defense Counsel in the sense that they will be able to see where they see eye to eye with the case handlers of the Turkish Competition Authority and where they feel that there is still a divergence in opinions. This is helpful because the more sophisticated the additional opinion gets, the better the Defense Counsel can address the board in its third written defense. Because in the first and second written defenses, typically you are addressing the case handlers and you're trying to debate with the case handlers and explain to them the situation. Whereas in the additional opinion, the case handlers have said their last word, and therefore your third written defense is more directed at the board almost. You're saying, here's what we could agree on, here's what we couldn't agree on, here's why we don't believe they're getting this case right, or we feel that they should have looked into this as well, whatever it is that you want to say. And it is difficult to do that kind of an exercise vis-a-vis the board if the additional opinion is not appropriately picking apart the defense that you have adduced, you have filed in the form of the second written defense. So the case handlers having 30 calendar days is advantageous also for the defense attorneys too, and the defending entities, obviously. Next slide, please. Right, so overall, and I'm coming to the end of the presentation. I had promised a 1-hour presentation, and we're hitting exactly the 1-hour mark. The amendment introduces several new dimensions and changes, which promise a procedure that is more efficient in terms of time and resource allocation. And they serve further clarification on the authorities of the Turkish Competition Authority on its jurisdiction. And also during on-site inspections, they know exactly what their powers are. Obviously, in the absence of the secondary legislation, it is more difficult to handle the presentation. And with the secondary legislation, it's going to be more obvious to us what particular tendencies the Turkish Competition Authority is showing, now that the ball is not in the court of the lawmaker, but it is in the court of the administration that is going to fill the gaps in the law through secondary legislation. So there's a question. Do you view the amendments as fruitful steps that will decrease the workload of the authority when it comes to non-hardcore violations? What would you look forward to in secondary legislation with respect to the commitment and settlement mechanisms? Thank you for this question. This is a very good question. So I do believe that the amendments will serve as fruitful steps that will decrease the workload of the authority when it comes to non-hardcore violations. That is my belief. But I don't really feel that that is going to be the salvation of competition law enforcement in Turkey. If the following flip side of the coin is also observed, then it's going to be fabulous, which is that as eager as it is in getting rid of non-hardcore violation workload, the Turkish Competition Authority is also using these changes in the legislation as a means of closing certain borderline files through the authorities that are bestowed upon it now with the new legislation in terms of the CX test, for example. That's a big question mark. It hasn't been the tendency of a lot of the agencies. You know how new debates have evolved in the world as well. Like innovation has made heavy inroads into competition law enforcement, but enforcement agencies were quick to articulate innovation worries and concerns and block transactions like DuPont, what have you. But when it came to innovation surplus, innovation efficiencies, dynamic efficiencies, meaning that a particular broad borderline transaction being approved, suddenly the competition agencies started finding it incalculable, difficult to integrate. Synergies. Whereas actually there was also a duty that they had to take that into account as well, if they are able to articulate the innovation worries in a progressive manner. Now, the same thing might happen here, i.e., we might be looking at a use of the amendments to get rid of the workload in non-hardcore violations, but when it comes to using the same changes that give you more room to maneuver in borderline cases, suddenly you're not making use of it. That would be a pity. I'm not saying the Turkish Competition Authority is a candidate to do that. I'm saying antitrust agencies around the world are candidates to do that, and Turkish Competition Authority is no exception. So I hope that they're going to be progressive on all fronts, be it pro-enterprise or be it leading to, and even in cases where it leads to more draconian enforcement against certain entities. What would you look forward to in secondary legislation with respect to the commitment and settlement mechanisms? Foreseeability. That's what I would look forward to, basically. I would want objective criteria. I would want there to be enough criteria that tie the hands of the Turkish Competition Authority in making sure that there is no discrimination, that we can explain in 5 years, 10 years from now, looking into the body of precedents, why a certain case has benefited from settlement or commitment, but why another one couldn't. That is a particular challenge in emerging markets because there's an inbuilt doubt as to the objective, the fairness, the objective attitude, the equitability of enforcement. So it will be important that the secondary legislation is not using soft language, speculative language, but rather parameters as much as possible. With that, I'm at the end of my presentation. If we can go one more slide, I think we're there. There you go. That's the thank you slide. So thank you. And I believe there aren't any further questions. I hope it was worth your 1 hour, and I hope I was helpful. Needless to say, if you were to have any questions, I'm happy to respond to your competition law questions in Turkey through the email address that you have seen in the previous slide. Thanks a lot.